Right, welcome everybody. This is a properly convened meeting of the hearings panel called for the purpose of hearing submissions in relation to a resource consent application for subdivision and land use consent. That's RC 250374. I'll ask the Minute Secretary to report on proceedings to date.
Statutory requirements under Section 95 of the Resource Management Act have been complied with. Section 42A report prepared by the planning consultant has been circulated to address for service and all submitters. The submissions received have been identified in the report.
Thank you. First of all, just welcome everybody. I will do some introductions first and then we'll finish off the procedural. Tracy Patterson, Chair for today.
I thought she was introduced.
I was going to put my hand up.
Well,
Mark, it's just for point of clarification. Martin has got new hearing aids, so just in case you
He's got music on by accident. Just give him a minute.
I have to work with these two other
I read the side.
gentlemen. Welcome there.
Sarah Brown, Commissioner from the Councillor. Did you see that? I'm the Minute Secretary.
Thanks. I'm the Council's reporting officer, planning consultant, and I'm the author of the Section 42A report.
Thank you. Jake, would you like to?
Thank you. Jake Woodward, Resource Management Planner. I'm Phil Page. I'm lawyer for Paddy.
Nice to meet you. Welcome. Just you'll see a little sign at the front. This is being recorded, just to let you guys know. So the process is obviously the planning. Mr. Woodward will do his part, where we will have some questions, and then we will go through the process, ask our planning consultant, Ms. Banks, to go through her report, and then you guys will get your reply. Is there any procedural matters that have arisen?
I just like to note that one of the submitters is known to me through previous professional capacity, but I don't think there's any conflict arising from that.
Thank you. So at the conclusion of today, we may need a site visit. We were generally familiar with the area, and of course you can rely that we have done the Google Maps search and we have got all your material, but we may need a site visit depending on how today goes. But in that extent, if we do, we'll be in touch to arrange that with you guys, if that's okay. The other thing I just wanted to mention is Sarah does have a significant back injury at the moment, so she needs to stand up or move about. Please don't be disturbed. She's not leaving the room. Yeah, so just letting you guys know that. Other than that, I will. Okay, so then we'll just ask for a motion that the Section 42A report that was prepared be accepted. Thank you, Martin. Thank you, Sarah. Those in favour? Against? Okay. I'm just going to move the minutes of the hearings held on the 14th of April, the 28th of April, and the independent hearings panel, which is RC 250305, are a true and correct record, noting that they are confirmed on the basis of the written record and do not alter the substance of the panel's decision. Thank you. Thank you, Sarah, and I'll second that. Those in favour? Against? Carried. Right.
I think it's me for starting. And I'm going to start in an unusual position, which is by asking you to have a look at the summary that Jake's just handed out, because it has on the very last page of that summary a copy of the proposed scheme plan. Just wanted to sort of step you through that, just to make sure that we all have a spatial understanding about what's going on before I address my legal submissions. So you can see, if you look at the scheme plan, the access coming in off Pearson Road, and the existing main residence is shown as lot 1. That's where Paddy is at the present time. And the existing consented visitor accommodation dwelling is shown on lot 2. And what Jake has done in his evidence is had a red building platforms drawn around each. And also in relation around the 4-bay garage, which is on lot 2, and an area for a new garage potentially on lot 1. So the proposal now before you includes those building platform areas, and those building platform areas are proposed to try and resolve a concern that the 42A report author raised about the potential for additional residential units to go on each of the subdivided sites under the dwelling rules. So we're trying to nail down the proposal to what's actually there on site that you will go and see. And I do ask that you do go and do that. I found that extremely useful spending time on site yesterday. And I think that would be helpful. So the only new built form which could potentially arise as a consequence of your decision today is a replacement garage for Paddy on lot 1, where that red rectangular box is shown just on the northeast side of the driveway coming in. Essentially, the theory of the case for Paddy this morning is that nothing changes in the environment if you grant consent. What you see is what you get. And if you're worried that that's not quite right, that then something else might happen that you're not seeing on site at the moment, then our invitation is to you is to express that, and we are happy to offer conditions to ensure that what you see is what you get. This is not a Trojan horse for a different development. This is just Paddy saying, hey, I want to downsize. I've got 2 dwellings. I only need 1, and put them on their own titles. So that's the case for you. The purpose of legal submissions is a little obscure in the sense that there's no debate about what the law is, about activity status or what laws are engaged or what they do, or any of that kind of stuff. We're all on the same page about that. Subdivision is non-complying, but the conversion of the dwelling on lot 2 from travellers' accommodation to residential activity is a fully discretionary activity. I agree with what is said in the 42A report is that they each enjoy their own separate status. There's no need to merge them, because even if you decide that you are happy with converting the travellers' accommodation building to a house, but you're not happy with the subdivision, we still want consent for the land use element as well. So those 2 things are separate proposals and have their own separate status. Nothing much turns on that status because it's agreed between the reporting officer and Jake that the 104D test for non-compliant is passed anyway. So you all end up in the discretionary regime. And the importance of the discretionary regime is it's fully discretionary. And what that means is that everything is on the table for you to control. There is no limits to the conditions that can be imposed to manage effects on the environment if you have concerns about effects on the environment. And that's the purpose of my paragraph 7, is to say, look, you can impose any condition that you like to manage an effect on the environment, or if there is a scope issue, you can impose a condition that's offered to you. And what we're here to say is that Paddy is prepared to offer conditions if there are concerns that are raised which need to be addressed, but you're anxious about the scope of the ability to do that. We can overcome that through making a conditions offer. And that's, as I say in my paragraph 9, that's one of the frustrations that we have, is that the 42A report quite sensibly addresses the potential for future activities on either of these lots, but then doesn't take the extra step to say, if we're worried about those future activities, how can they be controlled to achieve outcomes that's consistent with the policy framework in the rural resource area. And this is what Jake's evidence has tried to do, is to say, all right, understanding your concerns about the potential for future activities, how do we manage that? And the suggested way forward is through having identified building platforms with a condition which says you can't construct anything outside of the building platform. on my page 3, I begin a discussion of the law in relation to district plan integrity, because that seems to me to be the main issue that's been raised, is that we've got a 2 hectare average rule, which applies in the rural residential area, and that this is a 2 hectare block, which is to be divided in half by consent. And so, well, what does that do to plan integrity? What I've done is set out the discussion of the issue from the Court of Appeal's decision in Dye and the High Court's decision in Rodney District Council in Gould. And so what I want you to take from those legal submissions, and I'm not going to read them to you, you've had the chance and you've got all the cases, is that the Court of Appeal in Dye made clear that there's no such thing as a precedent effect, strictly speaking, because you're not bound by previous decisions. Whatever happened in the past happened. Your job is to make a decision on the merits of the application that you've got. Secondly, in relation to integrity, the High Court in the Gould case did 2 things. It made clear that that is not a compulsory consideration. It's not wrong for you to think about it, but you don't have to. There's nothing in the Resource Management Act that refers to the integrity of district plans. It is something which councils are frequently concerned about, particularly when a district plan is young and has only just gone through the first schedule process, but it's not something that you have to address. So in my paragraph 15, I've set out what the High Court in Gould set up as a guide to when integrity might be a useful issue to think about. The first step is that if the proposal irreconcilably clashes with important provisions of the district plan, and secondly, it is likely that further applications will follow which are materially indistinguishable. So those are the two steps, and we say that we don't address either of those steps here. And firstly, the irreconcilable clash aspect. The rural residential provisions do not have a minimum site size. You've read Jake's evidence, which takes you through the provisions, which explains how the averaging system works. So the fact that we've got in this application 2 1 hectare lots that would result are not irreconcilable with the averaging process, because we've seen in the local neighbourhood there are a number of lots already that are 1 hectare. So a 1 hectare lot is not incompatible with what the zone outcome envisages. It's just that we haven't averaged ourselves to 1 hectare lot. And so what I want you to understand from both Jake's evidence and from what the plan provisions say is that the 2 hectare averaging rule is not an end unto itself. It is a way in which the plan's objectives and policies are given effect to. And so in order to decide how you decide that, then you go back to those objectives and policies and say, well, what outcome in the environment are they anticipating is going to occur within the rural residential resource area? The trouble is that there's not a separate objectives and policy framework for the rural residential resource area as opposed to the rural resource area. And so the same objectives and policies apply to each. So the key policy here is 442, which I've set out at my paragraph 23. And that policy is to manage effects of land use activities and subdivision to ensure that effects on open space, landscape, natural character and amenity values in the rural environment are avoided, remedied or mitigated through, and it's got 1, 2, 3, 4, 5, 6, 7, 8 ways in which that can happen. It's policies 442A to H. Now, my submission is that in the rural residential resource area, it's really B that's the key here, which is that development which is compatible with the surrounding environment, including amenity values of adjoining properties. that's the key. And what I want you to understand about that is that it's not saying that a specific environmental outcome across the whole of the rural residential area is anticipated. What it's requiring is for you to form a view about what the existing environmental character is and what is compatible with the amenity values of adjoining properties. In some places that might require larger sites, in some places smaller sites might be appropriate. It's all about the factual matrix that's there and what the environmental conditions are like. So it doesn't require any specific outcome in terms of site size. It's a factual inquiry about amenity compatibility with neighbours. My submission, and this is what I say at paragraph 24, it is a policy that enables very flexible outcomes based on the immediate context of the proposal. And so when you think about policy 442B is really the engine room for the rural resource area, the flexibility of the averaging rule actually makes some sense. But because of that inherent flexibility, in my submission, that a decision which says it will actually, in the immediate context of this site, 1 hectare lots are appropriate, doesn't give rise to issues of plan integrity. It's simply a factual outcome of your inquiry. Now, you will have seen from Jake's evidence that there have been a number of 1 hectare lots that have been created both through subdivision and as a consequence of the averaging rule in the Pearson Road area. And the 42A reporting officer does acknowledge that smaller lot sizes can be anticipated with an averaging rule framework. My submission, there's nothing wrong with that outcome. Smaller lot sizes are allowed for and anticipated by the plan, but it must be considered in the local amenity context. So where we depart from the officer's advice to you, and this is what I address at my paragraph 29, is where she says that the subdivision would be a significant departure from the anticipated, from that anticipated by the district plan. My submission, that's a factually incorrect statement. The immediate environment already contains 8 lots between 8,000 square metres and 1.2 hectares. The proposal is actually consistent with the existing pattern of development. Or another way of thinking about it, if a precedent effect is relevant at all, then the precedent already exists in the area. So this application doesn't create anything new. Now, I want to come to my page 8 because one of the things which is apparent from the case law is that integrity of the plan and precedent effects tend to be much more to the fore in the court's thinking, where you've got a newly minted plan that's been through the first schedule process. And the case that I refer to in my paragraph 31 is Ahureka Trustees and Auckland Council, which was a substantial subdivision development straight after the Auckland Unitary Plan became operative. And so in that case, the court held that integrity considerations for newly minted plans may hold greater importance because plan provisions have not become dated or overtaken by other circumstances. Now, I want to contrast that with what you've got here. We've got a district plan that became operative in 2008. It was promulgated at a much earlier time than that, but went through its first schedule process in 2008. 2008 was, of course, where the earlier subdivision that Paddy attempted was applied for and declined. The district plan at that stage was hot off the press. So it is understandable that the council might have been concerned with the proposal back in 2008 with a brand spanking new plan, but here we are in 2026 and the world has moved on. So my submission is that concerns that council might have held in 2008 to say no don't need to concern you now, because the circumstances of this district are very much different, in Cromwell in particular. And what I've done is set out from Stats New Zealand the graph on my page 8, which shows you that when the plan was promulgated through to about now, the population of Cromwell is near enough to doubled in that time. And at a national policy level, we now have a new well, not new, from 2022, the NPS on urban development, which is the government's response to concerns about housing affordability. So the availability and supply of residential housing into the market is now a much more pressing issue for Cromwell and New Zealand generally than it was in 2008. And I want you to, why that matters is because the application to convert the travellers' accommodation into a residential unit, my submission, increasing the permanent housing supply in Cromwell is now a more pressing policy issue than providing for travellers' accommodation. And so that part of the application, at least, is consistent with increasing urban housing supply. I mean, this isn't urban, but it is nevertheless increasing residential housing supply by 1 unit. Turning to last comment I make on precedent effect, this is at page 9 of my legal submissions. You can be satisfied that there are unusual circumstances in this case, which is going back to where we started looking at the plan. Nothing on the ground will change as a consequence of you granting consent. You've got 2 dwellings already. All we're saying is that let the second dwelling be used for residential and let it be on its own title. Somebody walking along the walking track along the riverfront or driving along Pearson Road or even a neighbour will have no idea that conversion has been allowed to happen. There's no environmental consequence that arises from you granting consent. And that's an unusual set of circumstances and one which is most unlikely to be repeated in this neighbourhood. Certainly it wouldn't be a repeatable exercise for the land next door to the southeast, which is the big block shown on Jake's plan, Block 2, DP 504660, which is the former vineyard. They don't have the benefit of having existing dwellings on the property in which to structure a subdivision around. I don't think you need to be worried about precedent effect. As a matter of law, it's not compulsory. On the facts, this is an unusual situation, and any concern that you might have about future development can be managed through conditions if you're worried about that. And so what Jake and I would particularly like you to do is engage with us and saying, well, these are our concerns, and we can work on solving them for you. That's what we'd like to do.
Thank you, Ms. Page. Questions? Mr. Page.
Mr. Page, in relation to the travellers' accommodation, what were the consent conditions applying to that originally, as far as the operation of it?
I don't think there's any conditions applying to the operation of it. There was a consent condition requiring a pittosporum hedge of 1 metre high around it, which is shown on the plan in the 42A report. I think Rabbits ate that.
Yes, it is.
Now, the planner has correctly recorded. Oh, there we go.
Other than the number.
Yeah, no more than 6 fee-paying guests at a time in travellers' accommodation. It's a 4-bedroom house, so that seems kind of intuitive. And then, yeah, and the rest of it's just around service provision. So apart from a 1 metre high pittosporum hedge and not more than 6 people at a time, that's the only operational constraint on that. So here's the interesting thing. If Paddy decided to sell down the property into a holding company, he could rent that travellers accommodation unit to himself on a nightly basis of $1 permanently. And that complies. And then sell the holding company. So there is a way around the distinction between travellers accommodation and residential, which is available to Paddy if he wants to be clever about it and go down that path. That's not how we want to play. We want to actually be upfront about having 2 residential units which are separately owned. We think that's a better solution.
The Eastern Road Society's submission on water tanks.
Mhm.
To that,
Jake?
is that Jake?
Yeah, I think that's more of a Jake thing.
Might go back to them.
We'll come back to that, okay.
Yeah.
If I sort of chat GPT your submission and condensed it,
Mhm.
would I be right in assuming that the basis of your argument is the fact is that it's 2 existing residential units
That's one, yeah.
and
And the other is that the plan's at the end of its statutory life. Let's not get too uptight about its integrity.
if we knew what we knew now, possibly a plan change at Pearson Road would have been the.
Yeah.
I do have a couple of questions. Now, first of all, I just wanted to chat about the right of way.
Mhm.
You'll see that there's the other submission from
Mhm.
5 Carolina.
Mhm.
Can you just, so I'm 100% satisfied that the suggestion is to release the point C.
Yep.
Legally, does that essentially do what they say, 5 Carolina say? Does it actually mean that I mean, obviously you've still got the balance of the easement for the right of way.
Yeah, but it creates a break, so it's discontinuous. And so Paddy is happy to do that and can do that. And so what the submitters seek, we're happy to engage with them. As far as we know, it's never been used.
No, never.
But it's legally there, and Paddy's happy to let it go.
Yeah, okay. No, I understand that part, but I'm just meaning, so with that, from a legal point of view in relation to the right of way, that break in the chain, is that sufficient? Or any, let's say some hypothetical argument, I don't know, we're not there at the moment, but legally if someone said, well, I need to be able to get down to the lake, is that going to be, or to the gravel pit, is that something that could ever be pulled back?
No,
It
no,
couldn't
no.
be.
Once that break's gone,
Yeah.
The extent of it, and so Jake's got is that on the back of you? Oh, here we go.
It's on this one.
Yeah.
This is today. Yeah.
So the bit. So the bit that's at a diagonal from the elbow in the corner, if Paddy releases that, then no one can then use what would remain on lots 2 and 3 to access the gravel pit on Crown land next to the river.
So what if somebody came from the gravel pit up?
Yep.
And stopped at the boundary, which I understand that little section on the diagonal would be gone.
Yeah. Well,
I know I'm being really pedantic with this point. I'm just making sure that we are absolutely, that you're legally satisfied that someone who's trying to be smart, maybe not even with you, someone in the future that was having neighbours at war, would do something.
Yeah. Well,
like that.
I mean,
But it would still, the balance of that would still be in favour of the applicant's site, even though it doesn't connect in any way, shape or form because of that.
well, I mean, the rest of it remains, and so legally it's there as an instrument, but you could only go up it and get as far as the boundary between lot 3 and lot 1, and then you'd have to stop.
But you're confident that there's nothing that we should be aware of that.
No, I can't see any any basis on which that might come back and bite us on the backside later.
Okay, thank you. So basically, you're just confirming what 5 Karamani is?
Yes,
Okay.
yes, I am.
Replace that. Okay. So I guess if the 2 hectare rule, which we do have in our operative plan at the moment, if that is essentially a trigger for assessment.
Yep.
When in your opinion, would that actually become something that's actually relevant? Because what I'm hearing is that you're saying that in this circumstance it doesn't, but in what circumstances would it?
Well, I mean, what you do is, having triggered the assessment, that you then go back to the policy in 442 and say, do the changes which are proposed match up with the outcomes envisaged by the policy? Now, the problem is the policy isn't terribly directive about what those outcomes look like. And so it's a judgment call to be made by you about whether the proposal is consistent with the amenity values of the surrounding properties being rural residential or not. I mean, the fact that you can see houses is not a problem in the rural residential area because it's what the rural residential area is for. It's not rural, it's not the rural resource area, it's not in the ONL or any of those places. So it's a question about amenity. Is the amenity expectations of people living in the rural residential area going to be maintained by the proposal? That's what you have to ask yourself. There will be circumstances when the 2 hectare rule seems perfectly appropriate to maintain that amenity. There will be other circumstances where you might say it doesn't matter. We're simply saying that this is a doesn't matter one.
Do acknowledge that the plan is aged, and we had the rural chapter had actually been started.
Yep.
And then government put a stop.
Yes.
On that. So unfortunately, here we are.
Yeah, I'm aware of that.
Yeah. And we have to wait probably another year or so before we can even think about starting that process.
And trying as best as I can to understand what the minister was thinking. When you look at the planning bill and the natural environment bill, what they do explicitly is take landscape amenity values off the table unless they are ONL values. And so I can understand why the minister might have said, look, let's wait until that change in policy direction beds down in the Act before you have to rethink about what your rural zones are trying to achieve, because whether or not it's appropriate to structure your rural zones around rural amenity landscape values as opposed to ONL values is likely to be a key issue. And I kind of get it. It's really annoying for you because you guys are ready to go. But that's what we've got.
What we've got.
We get the select committee report back next week, so that'll be interesting.
Yeah. Right on 27. Okay. So under section 84, we still have to give effect to the plan.
Yes,
So am I correct in saying that what you're suggesting is that despite section 84, we still have the authority to actually apply a relative, I guess.
Yeah, so giving effect to the plan doesn't mean not granting resource consent, because resource consent processes are provided for in your plan. You can apply for a resource consent to breach a rule if you want to. So there's nothing inconsistent about granting a resource consent. It's more about what do your objectives and policies require in the granting of a resource consent. So that's why we haven't spent too much time getting tied up in the 2 hectare averaging and how the maths work, because the decision making that drives your resource consent decision is giving effect to your objectives and policies. And they're pretty flexy in the rural resource area. So it's effectively for you guys to go along, have a look, which is why I suggest you go there. What change to the environment is going to arise as a consequence of granting the consent? Is that consistent with your neighbour's amenity? If nothing changes, give it a tick, move on. Or if you're worried about the changes are potentially on the cards, if you grant this, tell us what you're worried about. We'll offer up conditions to manage that, so you can be satisfied that you're achieving your objectives and policies through granting consent. Just to take an example of the kind of thing that you might be interested in when you go there, what's really obvious when you're on site, and if you go to the travellers accommodation unit where I was with Paddy yesterday, and you're looking towards the river, is that you've got a great big open space in front of there, which is actually really nice. And it would be, in terms of providing views out to the river, and similarly, when you're on the walking track on the other side of the boundary looking back, there's a lot of open space that's there. How do you look after that? How do you preserve that through the granting of these conditions? Are there conditions which could secure that? For example, what does a boundary fence look like between those two lots? You're not going to want a 2 metre high concrete block wall. That would be bizarre in the rural environment, but you might think that post and rail or traditional post and wire stock-proof fencing might be appropriate in that environment. How do you manage that from an amenity point of view? It's simple, impose conditions. And that's what we're here to say, is that there are so many ways to skin this cat. We don't have to get too worried about potential future scenarios that you can't manage now.
So just in light of your submissions, and you refer to the housing information, but do you have any legal basis to give a greater weight for residential activity as opposed to traveller activity?
Well, nothing's changed in your plans policy framework. All I'm saying is that when you look at what the NPSUD is trying to do, it is to try and ensure competitive markets by increasing urban housing supply. Now, we're not urban because we're in the rural resource area, sub-zone for rural residential, but the gist of the NPS is every little bit of housing helps. And so all I'm saying is that in 2026, you ought to be more concerned about allowing travellers' accommodation to be used for residential activities than the reverse. That wasn't an issue when the plan was set up in 2008. It was more about providing for the visitor economy. You've got plenty of those now. Visitors, that is.
This is a legal question.
Yep.
I'll probably ask this of Mr. Woodward as well. Does being factually unusual have a legitimate legal base for departure from the plan?
No, it doesn't. But it means that you don't have to be worried about it being a precedent. Departure from the plan is more concerned with the objectives and policies. We're saying it's not a departure. It's a breach of a rule, but it's consistent with what the objectives and policies want.
Okay, no, that's me. Thank you.
Thank you.
Anything further that's come up there? Stage?
Not at the stage, no.
Mr. Woodward.
Thank you, Commissioner. Quite a bit of dialogue before we get to the planning. You've covered a lot of key things, which is yeah, but that's fine, you know. Look, I suppose I've shared with you this morning just a cut down version of the planning evidence, just confirming you there's nothing new in there. It's just a copy and paste of a number of sections, so you don't have to read 33 pages. And you obviously have a scheme plan in front of you. I guess Mr. Page has covered a number of the critical elements of Section 42A report, which there's only perhaps just a few minor points that I can perhaps provide some value there. But as a starting point, in terms of my summary, paragraph 2, just for context, it would be worthwhile for the panel to understand how the travellers' accommodation has been operating since its inception in 2018. And so that resource consent doesn't have any operational control, which you've heard from Mr. Page, other than the fact that it has a limit of 6 people. And that's a product of the district plan allowing as a controlled activity for up to 6 fee-paying guests. For the last several years or so, Paddy and Imogene have been renting that property to workers to the district, so to speak, in the sense of a lease that might last for, say, 3 months at a time. And most recently, it included workers on the Shannon Farm subdivision based out of somewhere close to Wanaka. When I visited the site last year, you had members of High Country Contracting doing pest control all along North Bend and Bendigo, and they were there for a period of time. So, appreciating that there is a consent for travellers' accommodation, it has been operating in the context of, wouldn't necessarily call it permanent residential because they're not there permanently, but the nature of how that house is being utilised, how can that be distinguished from a standard residential activity? You're still going to hang your washing up and so on and so forth. The only thing I can think of differently is maybe you build your veggie garden or you put a trampoline out there. The district plan equally does not have any other controls around the number of days or anything like that. So that house is not being utilised inconsistently with its 2018 consent or the district plan. Just moving on from that particular point, both myself and Ms. Banks are more or less in agreement that the effects on the environment are no more than minor, and that's a point that's been made in the Section 42A report. But I talk about in my evidence a point of confusion in the sense that the proposed subdivision in terms of its size and the way that it's been set up had the potential to provide for additional domestication structures and what have you. I think Mr. Page has jumped right to the solution, which is, well, you can manage those through building platform or conditions of consent. And as you're aware, Section 108 empowers you to do so. But I think a key point that the panel need to be aware of is that with the exception of, say, a minor residential unit, all other aspects of domestication, sheds, which don't require resource consent unless you breach a skyline, that can happen irrespective of a subdivision. And you only have to look at the scheme plan in front of you, which has an aerial photograph that illustrates, to a large extent, an overwhelmingly consistent outcome, which is a main dwelling and a 3-4 bay shed. You will see the odd properties along Pearson Road that might have self-contained units of some description. But we're not seeing these people, we're not seeing the government turn around and say, you can now build as a permitted activity minor residential unit, and all of a sudden you drive down that road and you see a proliferation of these structures. The reality is that a lot of people who are wanting to establish out in those areas or reside in those areas are probably there for a reason, and it's that they might not like their neighbours. They want the space, they probably want the openness, they don't want to have a proliferation of structures on their property. So while I think to a large extent Ms. Banks is justified in saying that a whole range of other structures could theoretically be established, I don't think that's a product of a subdivision. If anything, I think that's speculative. But if that is a concern, you have a pathway that's been afforded to you by way of a condition of consent that can manage that. So my paragraph 3 to 8 is really around cumulative effects. And the section 42A report, nor does my assessment raise any concerns about cumulative effects being established as a result of this subdivision. And as Mr. Page has pointed out, we have offered up a plan that effectively is what you see is what you get. The point around precedent has largely been traversed by Mr. Page's legal submission. And Mr. Page has referred to policy 442. But I also think there's another helpful policy which is equally relevant, and that's 4410, which is titled Rural Subdivision and Development. And specifically, it is that policy that talks at length around, or at least provides an explanation as to how the averaging rule works. And it's something that I've been aware of for a number of years now, whereby, referring to my paragraph 10, and I'm going to read the explanation note for you as it relates to policy 4410. Council's duty under the RMA is to control the effects of activities. The creation of a new allotment on a plan has in itself no real direct effects on the environment. However, the control of subdivision, particularly in respect of minimum or averaging allotment sizes, is a tool to assist in controlling the adverse effects of the land use that follows subdivision. In some instances, adherence to an arbitrary minimum is not always the most appropriate approach. And this is particularly true for subdivision of existing activities. Furthermore, there is no difference in terms of effects on the environment between development of, say, an 8-hectare property and the same development on property having a slightly lesser area. Lost over a couple of pieces of text there, but paragraph 11, the key point is that the district plan is not concerned with the cadastral boundaries in of themselves. Okay, wherever the boundaries are, it doesn't generate an adverse effect per se. It is what follows. What's going to follow here? The activities are established. Paragraph 13, when we examine policy 4410 more closely, and I want to just divert your eye to the bottom of that paragraph 13, I've actually just copied and pasted the policy. I just want you to read the first part there, which says, to ensure that the subdivision and the use of land in the rural resource area, recognising that there's no distinction between the two, avoids, remedies or mitigates adverse effects. And it has a whole bunch of criteria, and then at the top of the next page, above paragraph 14, particularly through the use of minimum and average allotment sizes. So looking at that again, policy 4410 is to ensure that subdivision and the use of land in the rural zone avoid, remedies or mitigate adverse effects through the use of minimum, average and allotment sizes. The policy infers the provision of averaging as a means of achieving those outcomes in policy 4410. The policy, as Mr. Page has already alluded to, does not say maintain an average of 2 hectares. It doesn't say avoid subdivision, particularly if the density exceeds the zone. Instead, it identified the environmental outcome. Effectively, what that policy is trying to point out is that minimum and averaging allotment sizes is nothing more than a method of achieving those particular outcomes. And so we've already understand that both Ms. Banks and I agree that the effects are no more than minor. I find it difficult to reconcile that we could be inconsistent with the policy framework when it's specifically saying mitigate, remedy, avoid the effects of that activity. And I think that's one of the difficulties that we have in this district with the implementation of a district plan. So it's not necessarily a product of the applications that are before you. It's recognition of perhaps some of the shortcomings that a first generation district plan has. And we're seeing it being implemented in many different ways throughout the last 18 years or so. Paragraph 15, this proposal is not seeking an outcome that is inherently at odds with the receiving environment, Pearson Road specifically. And we can see a significant number of examples where non-compliant subdivisions have been deemed appropriate. And we can also see section sizes which are smaller than what we have here. As Mr. Page has pointed out, there is no minimum allotment size. Again, the averaging tool is nothing more than the averaging criteria is nothing more than to try and achieve an outcome. Those outcomes include open space, landscape, natural amenities, so on and so forth. There's no evidence that's been submitted to suggest that this proposal compromises those particular outcomes. Paragraph 16, the section 42A report does not raise concerns in terms of cumulative effects. And it doesn't go as far as suggesting that this proposal tips the balance such that a threshold for development to be absorbed along Pearson Road has been met. In my assessment, I consider that no threshold has been met at this point in time. And certainly, I've gone as far as indicating in my evidence that even the provision of, say, a shed on proposed lot 1, I wouldn't see that as an outcome that is inconsistent with the character and the general vernacular of what we see on the immediate adjacent properties. So recognising, or at least understanding that in this particular case, the proposal has applied the relevant tool, which is the subdivision rule. The subdivision rule has a density criteria to recognise. If you don't meet it, you then move through the process. And as we've determined, the effects are no more than minor. And I also consider that the proposal is not contrary to the relevant policy framework. And as a result, it passes both limbs of the Section 104D test. So I don't see how the granting of this subdivision would materially undermine the district plan where you are following due process. And just as the final couple of points, I've reviewed all of the submission. 3 submissions are opposing, 2 of which relates to the 2 neighbours that have an easement that crosses their land. There's a point raised by Commissioner Patterson. We've received legal advice from Patty's property lawyers, just effectively advising that it's only property and that of a neighbouring property that have a legal interest in that very specific link that provide pedestrian access. And with the removal of that link, there is no legal basis for anyone to traverse and utilise the rest of the easement. And then the 3rd submission in opposition from Ms Wilson and Raywin just raises concerns around precedent and cumulative effects, which my evidence had largely traversed. So there was no submission that I see as inherently concerning or that couldn't be addressed by what's being presented to you in our evidence. And then lastly, should the panel be of a mind to consider the granting of this resource consent application? I've reviewed the draft conditions that have been presented in the Section 42A report, and I've only really made 3 particular comments. First one is Ms Banks made a reference to reverse sensitivity that applies to the traveller's accommodation consent. I agree with Ms Banks that replicating that condition doesn't cause any additional undue concerns or anything like that, but that condition hasn't been explicitly referenced in the Section 42A, so I don't see an issue with adding that. If the panel felt that the need for the building platform was required in order to mitigate any concerns around future activities, then of course a condition of consent as well as subsequent consent notice requirements would be necessary, and I've provided some draft wording in my brief of evidence around that. And then lastly, there was a condition around the provision of a wastewater assessment to be provided prior to the issue of titles, but of course that was included in the evidence. There's no concern with establishing 2 separate septic systems. In terms of my closing statement, I just direct you to paragraph 24. The simple fact of the matter is that this site contains 2 established buildings, both of which are capable of accommodating long-term tenants in a district that is experiencing substantial growth. There are no adverse effects being generated by the proposal, and the concerns around cumulative effects can be mitigated. Pearson Road itself is characterised by allotments smaller than those proposed by this subdivision and represents an outcome that, in my view, will not compromise either the character or the integrity of a district plan, particularly when appreciating that adherence to an average is not a strict environmental outcome, but rather a tool to achieve the particular environmental objectives of the policy framework. We can all appreciate that this proposal provides for the well-being of present and future landowners, ensuring that any adverse effects are appropriately avoided and mitigated. I consider that this proposal is entirely consistent with the purpose and principles of the RMA. That's just a snapshot of my bits and pieces, so happy to take some questions there.
Talking about the Pearson Road Water Society's.
Thanks.
Yep.
So I had a direct conversation with the Pearson Road Society's secretary, Gillian. Basically, each property need to have 2 separate tanks. Currently, there are 2 tanks at the driveway, which you'll see as you drive in on the right-hand side. This proposal would need to establish another 2 tanks somewhere on the property. That could be established in close proximity to the existing dwelling, and I think Paddy has already been talking to Waterford, which is the Irrigation Society's preferred contractors. They can put that up in any location to accommodate the additional supply and firefighting.
And agreeing to do that, it's subsequently reflecting the conditions of the consent and granted.
Correct.
The water line is actually already in ground.
To me,
I'm just working through the conditions that with the building platforms that you're looking at, volunteering to register there. Are there any conditions around what can be built within them other than it being a building platform? Obviously, the suggestion is that on new lot 1, it would be a garage, but the cynic in me would say that lends itself very well to another dwelling in the future should this exercise be repeated. Would there be, would you be open to that being registered to be a utility building rather than residential activity in form within that condition?
I don't think there would be any issues there because effectively it's just trying to safeguard the ability for someone to enact an outcome that is consistent, which is, big sheds or whatever. So I'm just scrolling through my evidence to quickly find the wording that I've offered up. But if that remains a concern in terms of potential cumulative effects, then those conditions can be expanded for sure.
In this instance, understandably, garaging is an option, but in future, if the property was sold and there's a building platform there, then it could be seen to be able to be developed into further residential. So it's really just in line with what you're offering there. I would say would be deemed to be in line with that no further residential activity on that would be.
Yeah, that's right. And I've certainly seen examples where building platforms have been identified specifically for, say, non-habitable use.
Yeah.
Yeah, so the condition that I offered up at my paragraph 28 in my brief of evidence is the shed platform on lot 1 shall only be developed with a non-habitable shed. So we've actually already gone. Yeah, I've just reminded myself that we did add that because it was a conversation we had in terms of could be perceived as being used for something more than that. But
The planner has raised concerns about it being used for a detached minor residential unit. That's not the purpose of it. Happy to have the condition saying so.
Actually, that's good. Yeah, I mean, you do see a lot in there sheds of that size of often having ablutions and then they're able to be converted at a later date. So while it's not the intention now, just to protect the integrity of that.
Yeah, I agree, Commissioner. I guess it's just something about people in Central Otago. I find that over the last 10 years, oh, Jake, I want to get a consent for a shed doing it. Everyone wants a shed. And yeah, and because recognising that as a permitted, subject to the setback requirements and colours and so on, I'm just trying to put myself in the mindset of the section 42A author and say, well, the reality is that if we subdivide it, you can chuck a whole bunch of sheds on there. If that were to happen, okay, well, let's just put a platform and just that's of a size that could accommodate maybe a 3 or 4 bay. So we positioned it in what we thought was the most logical spot. I said to Paddy, where would you build it if you're actually going to spend 100 grand on a shed? Be next to that driveway. And then my advice to him is let's comply with the 10-metre setback for sheds in the rural residential zone. Is where it is. I just want to point out quickly too that the scheme plan has been drawn so that the extent of the building platform hugs the facade of the existing building so that there is no need to apply for additional setback breaches over and above what was consented for the existing dwelling in 2008, that shed in 2008, and the travellers' accommodation, albeit that travellers' accommodation complies.
Everything else has been covered. You are, I think, on the.
With the Irrigation Society, one of the applicants, one of the submitters raised the issue of Taumata Arawai and the 25-person rule. I accept that already there's permitted with the 6. On that basis, and this was raised by Ms. Banks, is that if there was an ancillary building put on there, as in a minor, that would raise the ability to raise the numbers in relation to the 25 people rule. Has there been any discussions with those submitters by the applicant or with the irrigation company in relation to the potential for triggering that?
Not specifically, however, I think in terms of the consideration of a resource consent, the main focus that we're trying to provide to the council is, have you got the quantity and the quality? In other words, can they be serviced? What happens beyond that, I think, sits within the context of the Water Services Act. Taumata Arawai has got their legislations and their regulation. I would look at that as probably more of a private matter between Paddy when he goes through that process and the regulating authority. But the key point to make is that there is a sufficient supply, and of course it is subject to regular water testing in terms of their water safety plan.
And I did see that, just correctly, there was his request that's going to be a consent condition, isn't it? The making sure there is a updated.
Yeah, so when I spoke to Gillian, she kindly provided me with the latest water test results, which is October 2025. And she said to me that they're due to do another test, which whether that's happened now, I don't know. But she said if there's ever going to be a non-compliance, we just did. And we have a water safety plan to deal with it. Paddy drinking that water today, we had it this morning. So yeah, I don't see a concern there. Sitting there. Yeah. We don't see any undue complication if there was a condition imposed. It's just a formality that would have to be done prior to 224C.
Is there any site coverage rules that apply?
Not that I'm aware of, no.
Just making sure I've got this right here. And I see we've got the notification from the potential installer for septic disposal area. With the existing disposal area that crosses over into lot 2 from lot 1, is that proposed to be moved over to lot 1, or is it going to remain on lot 2 with an easement?
We have, that's going to be disestablished. We're going to have an easement over the boundary.
That's 43's got there.
Yeah.
Yeah.
Southern boundary for.
So just going back to the ancillary buildings, that's probably one of the things that we do have concern. I've got a bit of a concern about that in the event that there was one put on, arguably you could say, provided it meets all the requirements, if it was put, accepting that Mr. Page said about the open space, if there was something put further down that in future could give rise to arguments about subdivision because of the same situation that we're in now for renting out. So I'm just that, and that's applicable across both, and it's also applicable across the whole district. Was I correct that you guys took in your evidence, you said that that was, remember when that was I correct in saying that you addressed that? You said at paragraph 24, you said, I do not consider the provision of the small self-contained unit would generate a material adverse effect on open space values. An unpermitted, a permitted shed is excluding the permitted shed. We're talking about the self-contained unit. What about, you're saying that that doesn't generate material adverse effects, but there could be, what about issues with water and additional people using the property, if there was to be a possibility?
I think, yeah. So my experience with CADC is that any additional self-contained unit effectively requires a servicing capacity that is equal to that of a standard residential activity. So we consistently get engineering reports that requires at a minimum 1,000 litre per day per unit. In very few instances have I seen an outcome where it's as low as 750 litres. And that would have been a TBG unit, say Queensbury or whatever. I suppose at the end of the day, it will become an engineering sort of question around, well, can we produce additional water? The provision of an additional unit on a 8,000 square metre property, 8,500 square metre property, what does that mean in terms of the space required for a septic and so on? So that would be subject to further consideration. If there's a physical limitation that couldn't be engineered, then that would be your limitation. But I suppose the focus of my evidence has been more around the built form, so to speak, on the assumption that we could service it.
Is your question concern directed at the possibility that the 4-bay shed on lot 2 might be converted to a residential unit subsequently?
No, more so about an additional ancillary unit.
An additional, yeah.
For residential purposes.
Yeah. So that's what the building platforms are designed to try and avoid. So you simply cannot build outside the building platform. But if you did have a concern about the 4-bay shed being converted, the one on lot 2, then that's something else that can be conditioned.
And I think that your suggested clause does deal with that? Do you think that is sufficient enough? With
Well,
what
we-
Mr. Woodward has said?
We thought so, but if you're not convinced and that there's just, and the door is slightly ajar and you want to slam it shut, then slam it shut. Happy to do that.
Brad, how do you feel about that? Are you happy with Mr. Woodward?
Yeah, I think that mitigates fair. I mean, the condition is in there and it's right. It's just ensuring that is watertight. And I'm not, at this point, the application, yes, there's the integrity of that, a future sale. That would be quite clear to any purchaser. They're not coming in and thinking, oh, there's a platform, you know, I could get away with that. That's a quite clear condition that we can't.
If I could add to that, just in terms of 2 points, Commissioner. So the first one, just in terms of the servicing side of thing, I'm not aware of previous subdivisions where we've gone as far as, like we've done, let's just say we're doing 8 lot subdivision. Have we got 1,500 litre per day for each of those sites? And the answer might be yes, we do. And it's sort of left at that. And it's always been on the assumption of one specific dwelling. Now, that was obviously at a time where, because the district plan doesn't allow for, as a permitted activity, additional units. So you can appreciate that an engineer would simply say, okay, each site, if you've got 1,500 litre, deal with it. I guess nowadays, particularly as of January with the minor residential unit, it is my expectation, and it has been a conversation in the last several months, that they are thinking ahead in terms of, well, okay, you're doing an 8 lot subdivision, if you've got 1,500 litres per lot plus an additional whatever, just in case, because the permitted development parameters are, potentially another minor unit. But historically, it has always been, if you wanted to provide additional activities, you have to deal with it at that point in time. There's always I guess, a pathway in which we need to think about this further engineering, servicing side of things, building consent as well. So that point. In terms of the consent notice conditions, my experience with varying a consent notice, and the panel will be aware, is that certainly there has been quite a high degree of difficulties with varying consent notice in light of the Valentine Barker case. Unless there's been that material change in circumstances. But you'll recall from a hearing two months ago with myself and Mr. Page, is that the purpose of that consent notice needs to be understood. And certainly nowadays, and with the evidence you have in front of you, it's very clear why this consent notice is being offered up. So anyone who seeks to try and undo the outcome that we're putting forward to you today, in this day and age, and the way that we keep our records and the way that you expect our evidence to be produced, I think it should be clear, well, what was the purpose of that building platform? And I think that well and truly been spelt out by both the Section 42A report and what's been offered up. So I think that the condition that's been worded is all buildings and structures shall be located, this is my paragraph 28, all buildings and structures shall be located within the approved residential building platform as registered on the record of title. And the shed platform on lot 1 shall only be developed with a non-habitable shed. And the reasons for that are quite clear. So there's no harm in making it more wordy, I guess. But we need to recognise that the intent has been spelt out.
We may ask Ms. Banks to comment on that when it comes to that part. And one final question from me. With regards to the submitters that had concern only about the right of way, again, can you please clarify that by the releasing of the diagonal part, the part C, that will satisfy those submitters that are happy with the application? That was their concern. That was their one part of their concern. They wanted to remove that.
So you're, Commissioner, just to clarify, you're referring to easement area C that crosses over the northern part of lot 1?
Yes.
Of proposed lot 1, you're talking about the driveway specifically, or you're talking about the pedestrian?
No, the pedestrian.
Oh, yeah.
Pedestrian part.
Yeah.
It was which is addressed in there.
Oh, yes, yeah, yeah.
So then if that is removed.
I'm
needs to miss
satisfied,
it. Yes.
I'm satisfied that based on that legal advice, that the relinquishment of that easement breaks the chain. The reason why that came about was off the back of my previous experience with trying to relinquish the easement of Patterson Road, Kenmure. 22 people have a registered legal entitlement over that. In order to relinquish that, to vest it to the council, everyone had to agree. And while Paddy is happy to simply say, oh, I don't use it, I'm happy to get rid of it, well, the practical reality is that everyone that has a legal interest needs to sign off on it. Now, the issue we have with the underlying easement, which traverses a number of those properties, is that it's registered with 7 people. I believe it's 7 people. Whereas this particular link was the easy fix in that only Paddy's property and lot 1 DP 356255 are the only registered, so we're not proprietary, but the legal entity that benefit from it.
The dominant tenement.
Yeah, so they can obviously look to agree to have that removed. But I'm satisfied that when that link is gone, there's no legal entitlement to walk over that piece of land. If someone decides to physically walk over it for some reason, that'll be quite painful, but never mind.
But the submitters in relation to those lots, they will be satisfied provided that link is broken.
I can't speak for them specifically. I can all their concern is simply we don't want subdivision to occur because of more people crossing over an easement. Physically, you can't even see. But okay, well, let's just break the chain. And anyone doing their due diligence to buy, say, lot 2 of Paddy, would see that, oh, I can't cross over. And I believe Ms. Banks has incorporated a condition that requires that to be extinguished prior to 224C.
And in the absence of any submitters being here, we have to take it on their word on what they've written, that was their main objection.
Yeah, yeah.
Does that require a rewriting of the title, all the conditions for lot 1, 356255? Because obviously there's a.
As the title, well, it would be a revocation of the easement. It wouldn't be you wouldn't be redefining a legal parcel per se. The parcel definition isn't changing. It's just the easement entitlement. You can modify those easement entitlements, or you can add easements, obviously, at the agreement of the landowner and whoever benefits.
Yeah. From a land transaction point of view, it's simply executing a authority and instruction instruments that get registered to uplift to the benefit of an easement. So it's legally quite straightforward to do.
And that would be taken care of within this application as a whole. So there's no requirement there on the owners of that lot.
They don't have
That'd be taken care of on their.
But they don't have to do anything because the owner of lot 1 has the burden of the easement, not the benefit of it. So it can come off their title without them having to do anything.
Okay. That's it. Thank you. Ms. Banks.
Before we get to Ms. Banks, can I just take you to page 2 of the planner's report? Ms. Banks points out the landscaping plan that's part of RC 180151, which is the image in pink on page 2. And what you'll see is a requirement for a pittosporum hedge of a minimum of 1 metre high, so about hip height. And the report records the applicant's agreement that if you want to, then we can replant that, get it to grow again, because rabbits have now disappeared.
Yes.
Through the attention of some ferrets, which seemed bizarre, but anyway, that's how it worked. What the planner says is accurate about that, and we will do it if you want to. What I'm going to ask you to do is when you go out on site, ask yourself, does a 1 metre high pittosporum hedge serve any useful purpose? Because it would just be a nuisance to have to do that. If having been there, you look at it and go, actually open space looks better.
We'll certainly have a look at that. Are you suggesting that we need to, is there any just thinking, once if we were of a mind to consent this, the existing consent conditions in relation to the Pittsburgh hedge would be gone if we were of a mind to.
Yeah, so
Correct.
if you go on site and you look at that and say, why on earth would you want to put a 1 metre high pittosporum hedge there? Then simply record in your decision that that's not being brought down as part of this. Whereas what the planner's saying is that we're happy to comply with that if you want us to. And we're saying, well, yeah, we'll do it if that's what you want. I'm just asking you to think about that when you were there, because it frankly didn't make any sense to me when I walked that line yesterday.
Personal opinion, legal.
Is that?
Personal opinion, not legal.
Well, I'm inviting you to form your own view about that.
Okay. What's next?
Well, I think the conclusions reached in my 42-hour report and the general summary of it canvas. Just to summarise and go through that, the application or the activity status for a non-compliant subdivision consent or a breach of the 2 hectare lot size, and then separate to that, the land use can be considered for the second residential activity as a separate consent, which has its own status and is a discretionary activity. I have considered the environmental effects of the proposal, and based on as what has been outlined, based on a reflection of the existing environment and the character of the area and the existing buildings that are on the site, have come to the conclusion that the effects will be minor. And as has been discussed, those effects can be the concern that I've raised in regards to the creation of an extra site and the effect that that might have on generating other potential buildings could potentially be resolved with other conditions of consent, and as has been suggested, the identification of the building platforms. With regards to those concerns, the concern over the additional minor units that I have raised essentially stems from obviously creating an extra site, which then, based on the NES, could allow a separate minor unit on each of those sites now, whereas compared to the current status quo, which is effectively already existing on site, which is the main residential dwelling and a second residential activity. So the condition that's been offered to require all buildings to be located within those platforms, to some extent addresses that. As Mr. Woodward has outlined, he didn't consider it was necessary to restrict necessarily additional minor units on the site. From what I understand, just the location of them being within those platforms. And I consider that that's appropriate. The matter that's been raised about the water supply could be included as a consent notice condition. And while that would be subject to additional constraints over varying that, if it's to a technical purpose, and it's clear and outlined, then yeah, I don't think there'd be too much concern with reflecting that on it with an additional condition. There are other potential effects that may arise from, which could benefit from additional conditions, such as consideration of the type of fencing or delineation of lot boundaries. So if that was, could be a consideration to either restricting fencing or specifying the type of fencing that could occur on the property. To make sure that that open space is maintained. Or the appearance of open space. With regard to the existing character of the area and the discussion about the fact that the lot sizes are consistent with the surrounding area, not inconsistent with it. I do agree with that to some extent, and I have noted in the 42 report that the averaging rule does allow for smaller lot sizes, and clearly that's what has occurred. Where the concern is that I have with it is that that averaging framework has been sort of most been a clear strategy and one that is used commonly to use that averaging to gain a smaller lot size and then continue to kind of chip away at it. And that's where you get the concerns over precedent and plan integrity. With this particular site, that appears to have been what has occurred over time, and that all the previous subdivisions have complied with that bridging rule. And the smaller lot sizes have been able to be created in that way. And now we've got to a point where we get to the end of that, where the lot size is so small that you can't undertake the subdivision as a complying activity anymore. And so that's where I think the concerns around plan precedent integrity become more relevant. And I'm jumping around here, but where the discussion about the age of the district plan and the fact that it might lend itself to considering that the breach of that rule wasn't so has been through a Schedule 1 process, and that process came out with the determination of the average 2 hectare lot size. And I guess my understanding of that is that in an averaging framework, the idea would be that you'd have a larger lot size to balance out the smaller lot size, and in doing so, maintain the open space that is landscape character and amenity that's sought of the residential zone. In this case, we don't have that larger lot to balance that out. That's sort of anticipated by the averaging framework. And while there has been some discussion about the age of the plan and the fact that it potentially losing relevance, it's operative and it has been for some time, and that provision is there and has gone through a public process, whereas it's unknown what the outcome would be and I'm not aware of what the draft provisions were of a new chapter, and I guess they weren't publicly notified. They didn't get to that point. So that's where I got to with my conclusions of the 42 report, is that the effects I accept will be more than minor. However, the primary concern is with the conflict with the 2 hectare average lot size and the integrity of the plan. Mr. Page has gone through the case law relating to that and an argument why that shouldn't be of such a concern. With regard to some of the points that have been raised, there's been some discussion with regards to the provisions of the plan about policy 3.3, was it? Number it was. But there hasn't been any discussion of the objective. And the objective is relevant objective, which obviously the 2 hectare average lot size is a method to implement the objective. And the objective says to maintain and where practicable enhance rural community values created by the open space, landscape and natural character and built environment values of the district's rural environment, and to maintain the open natural character of the hills and ranges. I have concluded in my 42A that proposal is not entirely inconsistent with the provisions of the plan, but it is partly inconsistent just by the fact that it subdivision and potential additional buildings that are enabled by the subdivision can't maintain or enhance the open space values because it will practically result in some effects to that, some reduction of that. Just with regards to precedent and the personal the gold case, from what I understand, the two considerations are whether there's an irreconcilable clash with important provisions of the plan, and then if it's likely that further applications will follow, which are indistinguishable and equally incompatible with the plan. I sort of disagree with the argument that's being presented because I see that there is a clash and that 2 hectare average is identified as a tool and used to implement the objectives. Also, it's been suggested that site, with the fact that it's got an existing worker accommodation unit on it, is unique to the extent that it won't generate future applications that are similar. However, I wouldn't see that scenario as being particularly unique in this district. I think it's quite common that rural properties have either a second residential unit or a workers' accommodation, or a accessory building that they then later come along and seek to separate off as the situation current application is proposing to do. So I do think that those gold tests are actually relevant and that there is a clash with the provision that is important, and I consider that this granting of this consent would generate future subsequent applications that are similar. And there's been a bit of a contradiction, I think, in the evidence and the discussion. The fact that it's been suggested that the precedent is not relevant to some extent, but other applications have been referred to that have been recently decided in a similar sort of scenario, and they're being used as an argument that a precedent has already been set. So, and the comment has been made that the precedent may already have, exist. I think that that's relevant, and it's evident from looking at the surrounding pattern of development and lot sizes within the area. So that's really the key point for me in the conclusion that I reached in recommending decline of the land use in the subdivision was the concern about the likelihood that this granting of this consent could generate future similar applications, and the fact that that potential future scenario isn't been through a more comprehensive assessment process to determine is it appropriate for this part of the rural residential resource area to be just continually subdivided down into small lots. think that's mostly all I want to say, just on the questions that have come up about the right of way. I did have a discussion with the submitters and I suggested that they talk to the applicants' lawyers and talk through it a bit more because I didn't analyse the easement documents in any detail. However, I just and it's been said that there's no concern with removing that link. Just on a quick check of looking on that link, it appeared that it may have actually been attached to other titles. So I suggested to the submitter to go and make sure that removing that easement wouldn't actually affect anyone else. And I'm not sure whether it got to. I can only take, I guess, what's been said, that it won't have any other consequential effects. I suppose the only other comments that have come from them was that there was some confusion in the area about some of these properties and they thought that they had the ability to access through this area, and in a legal sense, that rights removed, that's fine in a legal sense, but there may still be this confusion with property owners in the area that they feel like they have the rights to access over this, and then subsequently through the remainder of the easement that exists. And I'm not sure what the implications are of moving a link that then reduces the rights that exist to the remainder of the easement. I mean, I have recommended a condition to remove that link, area C, is it? And as Mr. Woodward has noted, my condition wording would need some slight amendment because I have at the moment referred to the entire easement, which isn't what's been suggested.
You happy with that approach? I'd like to pick that up in relation to the possibility of that affecting anybody else, removal affecting anybody else, the implications. First of all, questions for Ms. Sorry, Ms. Banks, are you, that's you? Any questions for Ms. Banks?
If we didn't grant subdivision consent, but we were happy to grant the land use consent, so that the secondary dwelling went from accommodation resident into residential, can you just confirm what happens there if that lot stayed as one with the minor unit, how that would work? Would that, I just want to make sure I understand that fully. Like, does that need to be on a building platform, which would then need to be applied for as well as that minor unit application, or could that be put in? So the lot as a whole would remain, it would have a primary residential unit, a secondary residential unit, and then there would also be provision to allow a minor unit as well, or not?
Yeah, I think that's where the NES few shortcomings, I guess, and that it doesn't address the fact scenario that you might already have a second unit on a site.
Yeah.
It doesn't. Yeah, so potentially that could be addressed by condition that states that no further minor units could be established on the site, because the site would already have a main dwelling and a second unit, which should be deemed to be the minor unit.
Obviously, with the size of that, it doesn't fall within the descriptions of the minor unit being 70 metres. That how big is that travellers accommodation? Do we have a floor area? I'm assuming it's bigger than 70. So
Yeah, it is. I think it's about
143 square.
yes, so it wouldn't fall within the parameters of a minor unit as per the. So okay, so that would that need a building platform to be established as a minor if one were allowed? in this zone as is, does that need a building platform to go ahead? That can go ahead regardless, can't it? That's outside of the.
Yeah, that's where I say that the NES currently isn't clear, because if the landowner chose to come along now, irrespective of this application, different, well, you don't have to apply constructing another minor unit, potentially they could, because the existing workers' accommodation isn't specifically a minor unit in the NES.
So would you consider, if that were where we landed with this, and it remained as a one lot as a whole, with those two residential activities on there, would that be a condition that you would look to restrict any further units being put on there, or? I mean, we're concentrating on the subdivision, and obviously we said there's two
Yeah.
possibilities. Three.
Obviously, that would be appropriate, that you recognise that the site already has two residential activities, and that is the intent of the NES, to allow a smaller residential activity, and that would have already occurred. That would have be already the scenario that has occurred. So a condition recognising that no further units could be constructed would be relevant. The other thing would be that the building platforms that have been offered would need to be registered as a covenant if it was just on the land use consent as opposed to subdivision.
Obviously, that'd be appropriate if it was just the land use consent that was granted, that we still ask for those building platforms to be registered as they are drawn, because obviously that's indicative of what would be requested or conditioned if it were subdivision. If it were not subdivision, we're still looking at those building platforms to be part of those conditions.
I think so. I think that's still, they still go towards managing the effects of the additional domestication and reduction of open space character that could be.
Thank you. That's
You are not going to change your mind as far as your recommendations concerned in your 42A report. You're basing that on precedent effect as opposed to the actual environmental effects of this proposed subdivision.
Primarily, that was the conclusion. That was the basis of my conclusion. So, yeah, it's been, this page has outlined why perhaps the panel didn't need to be so concerned with that, and I've just outlined the reasons why I came to that conclusion, I suppose.
Just to follow on, so we're just confirming that there's been no change in your mind from what you've heard today. And bearing in mind the registered building platforms, including the possibility of the utility building on both lot 1. Essentially, as it stands there now, we've got the copy of this, as it stands there now, that if that was restricted to that building, those building platforms with no further subdivision, that change, was that you're still of the same opinion?
My views on the text of the proposal haven't changed, and I agree that the additional measures and conditions that have been offered are positive. So my views on the overall determination would be that on an effects basis, the proposal can be supported, both subdivision and land use. If the concern over precedent plan integrity is not a significant concern.
Just in relation to, can you clarify for me again your thoughts in relation to the argument put forward by Mr. Page and the applicant in relation to the age of the plan? and excluding what the council has and has not done. We are in that situation now. So do you agree with? Do you agree with the Mr. Page's assertion that the plan is out of date and can be interpreted more broadly, or do you believe that the alternative that the plan, given its age, needs to be adhered to?
Views of that the plan is what it is, and as we've said, the council needs to language. However, I suppose it's, yeah, I agree that there are parts of the plan that could be reviewed and improved, and that's obviously the process that council was going through before they were made to stop. But I'm not aware the direction that was taking, particularly with regards to provisions such as this, such as the average lot size. I guess what I'm saying is it is the operative plan, and to suggest that it should be something different, perhaps it should be, but we have to implement the plan that's there. I do agree with the position that's the views of Mr. Woodward and Mr. Page, that it's not a strict determinant of per hectare that has to be adhered to. It does come back to interpreting the proposal against what the objectives and policies are trying to achieve. And as occurred by previous decisions, previous consents have been approved lot sizes less than 2 hectares in the past. So it's not a determinative must be 2 hectare, and it comes back to what the objectives and policies are trying to achieve. And I've just noted that there's a slight inconsistency with the objective, but as has been discussed, when you look to the policy, it's about managing adverse effects, and that's where the resource consent process comes in, and the assessment of effects. You get proposals that are seeking to breach the minimum lot size.
Okay, so at page 90, which was, and this is page 32 of the application. It's section 104D. Test Mr. Woodward refers to it as broadly consistent. Please give us your thoughts on that. Is broadly consistent enough?
Section 104D test requires that only one of the limbs be met. So if the effects are minor, then that limb is met, and the second limb is whether it's contrary to the objectives and policies, and it's an overall consideration as to whether you can be partly inconsistent with some provisions, but not entirely, and it would still pass that section 104D test. So you'd have to be fully contrary to the objectives and policies to not pass that test, is my understanding. I think that's where Mr. Woodward's comments broadly passes that test.
And just in relation to the discussion about Taumata Arawai, creation of another lot, while it's still potentially a similar amount of people, do you have any, have you given any consideration for the possibility of any issues for the council in relation to issuing that, essentially contributing to the numbers of people and any subsequent PA requirements.
In terms of the ability to provide sufficient water supply to.
No, I'm thinking more in relation to the triggering the 25 people.
Yeah, given.
And indicating the council as opposed to in between the property owners and the irrigation company.
Given any particular consideration to that, but as I sort of suggested, I think that could be reflected in the condition if there's a point at which further review of the arrangements of that need to be considered when the number of persons reach 25.
Thank you, Ms. Banks. Okay. So
What do we do now?
allow you to, you may give your right of reply verbally. Would you like to take a short break so that you guys can?
Yeah, well, I think just to make sure that we're all on the same page, I think if we could grab 10 minutes now, that would be useful, and then I can give an oral reply after that.
Do we have a room for these guys to just give us a moment, we'll see what we can find. So you
So what we would like to do by way of closing submissions is, for reasons which we will get to, invite you not to close the hearing. What I'm going to do is to make some submissions about the integrity issue by reference to your plan provisions, which I have in my case book. 8 or 9 pages in, which we'll come to. Then we want to talk to you about conditions, and then we want to talk to you about the where to from here process-wise. So coming then first to your plan provisions, because I need to make these submissions because the plan's advice to you is still that there is an integrity of the plan issue that she's concerned about. What I want to do is explain to you why actually there isn't. So if you have my bundle of authorities and you go 1, 2, 3, 5, 6, 7 pages in, you should come to the objectives of the resource area. And you can see there's a page number reference at the bottom left-hand corner, and I'm on page 7 of 86. That makes sense?
Yeah, just bear with us. We'll just grab this.
Yeah, I know you need to scroll through awkwardly sized PDF, but I'm sorry about that. That's the best I can do.
What page do you make it? The 165? Is it?
Page 8, was it?
So if you look at the bottom left corner of the page, the one that I'm looking at says page 7 of 86.
Page 7 of 86.
If you tell me which one you're at, I can direct you to how to get to the one that I'm at.
Okay, so moving on. Oh, there we go. So it's our page 14.
All right, okay.
Our page 14.
That sounds about right. And so the first provision on the page, just so we orient ourselves correctly, says objective 4.3.1. Right, we're on the right page. The objective that the reporting officer referred you to was objective 4.3.3, so 2 down from that, landscape and amenity values. And just so that we understand how the architecture works, you can see there are cross references in italics underneath the objective heading, and it tells you the policies that give effect to this objective. So once we finish looking at 4.3.3, I'm going to take you to 4.4.2 and 4.4.10, which are listed in that italics. Now, reason why I want to take you to this objective and to its policies is to understand that when we're talking about the integrity of the district plan, we're not talking about rules. We're talking about what the plan's objectives and policies are for the resource that we are dealing with. Why it's important to understand that is because resource consents are by their nature consents to breach rules. That's how they work. So you don't think about integrity of the plan as being, will this rule be breached? Because every resource consent that you sit on will be a rule breach. Because that's why the resource consent is required, and that's why the application is before you. So the integrity of their plan comes from giving effect to its objectives and policies, right? Now, Objective 4.33 is important because it sets up the policies 4.4.2 and 4.10. And what it is to maintain and, where practicable, enhance rural amenity values created by the open space, landscape, natural character and built environment values of the district's rural environment, and to maintain the open natural character of the hills and ranges. So we can forget about the last clause because we don't have hills and ranges in this application. So we're only interested in maintaining the rural amenity values created by open space and landscape. That's what this application is about. So that's the objective, maintain open space and landscape. Now, if we go to policy 4.4.2, which is the landscape and amenity values policy, this is the one that I referred to in my oral submissions opening. The only part of that policy 4.4.2 that is relevant to this proposal is B, and this will be on your page 16 of the PDF. Development which is compatible with the surrounding environment, including the amenity values of adjoining properties. So that statement there is the policy about how to give effect to the objective, right? So the question for you is, does this proposal, also, is this proposal compatible with the surrounding environment's amenity values? And if the answer is yes, because those amenity values do not change, then it is consistent with the policy because those things are being maintained. And then if we go to the next page in the bundle, we come to policy 4.4.10, which is the policy for rural subdivision and development. And again, the only amenity part of that is A, the open space. And so that's the term that we've taken from the original objective, the open space, landscape and natural character amenity values of the rural environment, in particular hills and ranges. Again, we don't have to worry about hills and ranges because we don't have any. But will this proposal avoid, remedy or mitigate effects on open space? So that begs the question, what open space is there? And will this proposal avoid adverse effects on it? And if the answer is you are satisfied that open space is not going to change, then this policy is achieved. So if you follow that line of thinking through the objectives and the policies and find that they are achieved, then there is no integrity issue because this is what the plan's policy is for the rural resource area and in particular the rural residential area. Therefore, granting a consent that achieves those things, although it breaches the averaging rule, does not give rise to an integrity problem because the plans and the plan's objectives and policies have been achieved. So that's why we say, don't worry about the 2 hectare rule. we understand that it's about unders and overs. Big lots balance against small lots, and that's how you get your amenity. But if you look at this particular location, does that matter? And that's why I want you to go there and stand in the middle of that property and say, does that matter? What are the amenity values and the open space values of this location? And can we protect those through this proposal? And that's what brings me to conditions. In her reply, Kim referred to the potential effects of fencing and suggested that a condition might be required that lot boundaries can only be delineated through specifying types of fencing. We're very happy for that to occur, whether it be post or wire, whether it be rabbit foot wire fencing, whether it be sheep netting. We don't really care. But if you do care, then say so, and we will happy to offer you a condition about that. But you'll probably only have a clear view of that once you're on site. All we're saying is that, yep, we get it. That open space should be protected, and we're open to how that's done. In relation to minor residential units, we are very clear in the proposal that in return for the grant of the subdivision and the land use consent, we will agree to a condition that there are no minor residential units on either site. So it's a done deal. What you see is what you get. My instructions is that if you are not going to grant the subdivision consent, then that offer is not made. Paddy is going to have another think about what best serves his interest if he can't subdivide. So we're offering up what we regard as a positive environmental outcome that flows from the subdivision, because you can be absolutely sure that you've nailed down what the future environment looks like on both sides. And in terms of where to from here, what I'm going to suggest to you is that you do go and do a site visit. That at the end of that site visit, if you're satisfied you've got everything then you want, great, close the hearing, away we go. But my suggestion is that it would be useful to issue a minute once you've deliberated and done your site visit to indicate what, if any, additional conditions need to be offered by the applicant to address your concerns, and invite us to lodge a set of conditions which addresses those concerns. We'll no doubt work with the reporting officer to get a Word file of the conditions so that we can draft directly into those. And then we can file them. And if you want advice from the officer about those additional conditions, you can get it. But let's deal with this iteratively rather than not thinking that you have to know everything right now. Because you'll learn things when you go out there. When you deliberate, you'll reflect on stuff that might suddenly appear important that you didn't think of today. Tell us through a minute what your direction of travel is in terms of the conditions that need to be proposed. We can draft those and file them. And then once you've got that and you've satisfied that you've got everything you need, then you can close the hearing and then deliberate and issue your decision at that point. That I think is a better process than trying to work with what you've got right now when you haven't had the chance to go to site yet. Does that make sense?
Thank you. Thank you. No, that's we'll take that under consideration and do that. And just in relation to site visit, to I guess our administrator can be in touch. We just need to confer as to timing and
Yes.
things like that. Is there any times that because obviously we will come to site, we can, given that we know that it's a flat site and probably not too many, but you may have people that we need to, you know, obviously you've got a tenant, so we don't want to interrupt any tenancy issues. So we just need to, if we use, Jessie can get in touch with you guys. If there's any time that doesn't suit, that's really inapplicable, then we can do that.
I think Jesse can liaise with Jake directly about a time that suits you. Then Patty can make sure that
Yeah.
things are good to go.
One booking
Um,
for the whole month. So.
My experience is that ordinarily you don't want anybody to be there
Correct.
because you don't want to have your ear bashed by people outside the hearing environment. We get that, so we will make sure that you are left alone.
Yeah. We don't need to go through any votes or anything like that. We just probably need to stand on site.
There are no large dogs or stags in the raw or anything else charging around that could do you a mischievous.
Okay.
So that's all we've got to say. And
Okay.
thank you for the very constructive way in which Kim and you as the panel have engaged with this. And I hope we'll resolve any concerns that you might have.
Thank you. Okay, so the decision of the hearings panel is reserved. Formal decision will be in writing and will be available within the statutory period of 15 working days post the closing of the hearing. And in the event that the decision is delayed, we will, you know, any delays. Hearing is now adjourned.